Good morning, Mr. Chair. Tia Orr on behalf of the Service Employees International Union. We're in strong support of AB 525. Thanks.
Yes, my name is Hitpal Diola. I'm from Yuba City, California, Subway franchisee for 20 years, and I'd like the committee to pass this AB 525. Thank you.
Good morning. My name is Raj Bratz. I'm franchisee 7-Eleven from Sacramento. I also represent my Northern California 7-Eleven FOA, the locally over here. So I will request each and every member to support the bill.
Hi, I'm Lalikal, and I have a 7-Eleven in Sacramento, and I have a Subway too, and I am with franchisees about 15 years, and I request every member to support the bill. Thanks.
Good morning, Mr. Chairman and committee members. My name is Randir Golan. I'm franchisee in 7-Eleven 17 years. My 7-Eleven is situated at Hillsdale Boulevard in Sacramento. I'm asking for your support on this bill. Thank you.
Good morning, committee members. Haneshandra Chauhan, franchisee Subway and 7-Eleven. Request support for 525. Thank you.
Good morning, Ed Carter, retired 34-year McDonald's franchisee in Daly City, California. Please support this bill. Thank you.
Mr. Chair, member Sarah Flocks, California Labor Federation, in support of the bill. Thank you.
Good morning, Norbert Stone, President, California Black Chamber, and I truly support this bill because obviously small business is the backbone of this state. And really, we're all here to try to, expand the economy. So, thank you.
Richard B. Habib, Service Station Franchise Association, and Oracle AMP and franchisee strongly support the bill. Thank you.
Good morning, David Chase with Small Business Majority. We represent the 3.5 million Californians that own their own small business here in the state, and we strongly support this bill. Thank you.
Thank you. Any other witnesses and supports? Thank you. Any witnesses in opposition? If you could make some room at the table for them, please. Morning.
Hi. My name's Dean Heil. I'm with the International Franchise Association, and we represent franchisors and franchisees, and we are currently in opposition of the bill in its current form. We do really appreciate the author's consideration of our concerns, specifically the contracts in perpetuity section of the bill, and we look forward to continuing that discussion with them.
Thank you.
I'm happy to answer any questions that folks may have.
Okay. Any other witnesses in opposition?
California Manufacturers and Technology Association. I just wanted to echo the comments of Mr. Heil. Thank you.
Thank you.
Thank you, Chair and members. Kate Bell on behalf of the California Retailers Association, also in opposition. Thanks.
Thank you. Any other witnesses in opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Ms. Garcia?
Thank you. And I heard you correctly, you're working or talking to the opposition as this bill continues to evolve?
Yes.
Thank you. I know this is, we saw this bill last year also, or a version of it, and I think you're moving it in the right direction. The idea of how we reimburse the franchisees if they do take over, it needs to be amended, giving them pennies for the dollar for their life's worth. It's a little bit insulting to these owners out there. And so I particularly appreciate that you're addressing that item in this. And so I want to move the bill today with the condition they continue to work with the opposition so we continue to craft a better bill along the way and continue to have this important discussion.
That's our goal.
So that was a motion. The recommended motion is do pass to B and P. So I have a motion. Do I have a second? So I have a second. Thank you. Mr. Gallagher.
So on this bill, one thing that I'm kind of confused about is the substantial compliance. So let me just ask a couple questions with regard to that. Let's say the franchise agreement requires 5% of the profits to be paid to the franchisor, and the franchisee pays 4.5%. Does that qualify as substantial compliance under this bill?
it's my understanding that that would be a substantial breach of the agreement, but I'll turn to one of our witnesses to give a more accurate. But I think what we described earlier on is that if there were any instances where the franchisee was not in compliance with stated laws or significant portions that are recognized in the agreement that are called out, that those would be, I think it was described as a flagrant foul.
Yeah, actually, non-payment of fees is one of those conditions that allows for quicker termination. I think in California it's only 5 or 10 days. So that
Mr.
one
Chair,
specifically.
I'd just like to make sure we understand the question.
So I'm just concerned about money. You know, when there's a contract, a franchise contract that says this is what you're going to pay, whether it's a percentage of profits, fees, under this bill, no one's going to be able to say, well, hey, I paid almost all the fees, but not all of them.
No, that's not possible under
That
this
wouldn't
bill.
be considered substantial compliance.
That would not be possible under this bill, sir.
Okay. Well, I think that's important.
Yeah, it is. I agree.
As a former, if I...
There are 11 sections in the statute currently that allow for immediate or almost immediate termination, and those are not being changed. This is the catch-all that would allow them to terminate for any provision, no matter how small, no matter how tiny. So,
How about failure to turn over sales receipts to the franchisor on time?
that is not in the 11 sections to my recollection. But the franchisor does have a provision that allows them, upon multiple violations, to terminate immediately. So if it happened repeatedly under the provisions that are currently out there, they could terminate the franchisee. So it's one foul, you're not out, but if you do it multiple times, you're out. And the statute also, I've heard this from the IFA, the statute allows immediate termination if you violate health and safety laws, for example. If you're making bad food and you don't correct that immediately, you can be terminated despite these amendments. That's still in the statute. So we want to protect them from, we protect the public from these real egregious violations, and statute does that. But we don't want the franchisee to be at risk for these minor fouls.
But Mr. Chairman, I think just to complete the answer, if you look, Mr. Gallagher, in the law that was passed for other franchisees in this state, protecting folks in this state, business people, the auto dealers franchisees, you'll find your answer, and it's very clear. And that was done in 1973, and Governor Reagan signed that bill to protect those in our state. And so all of those answers are there for you, and I'd be happy to sit down with you on that.
And I appreciate that. I'm just trying to probe this bill to figure out what it is that I'm voting on. So
Can I actually give
think
a real-life example? I mean, I'm a Subway franchisee. I can tell you how it's done in Subway on sales.
Sure.
I'll be very quick.
Be brief, please.
Basically, if you don't report sales on time, they estimate your sales and add 25% to, or 10% to what they estimate. So they're pulling their money out no matter what. Estimating sales or hiding sales is not an option, real life example.
Okay. So what I'm hearing is that money is, in terms of fees and portion of profits paid, that nothing in that is going to be included in substantial compliance under the bill. Maybe just hearing from International Franchise Association, is there certain things in here that you're concerned about that would be considered substantial compliance that in your mind would be a material breach?
Right. Currently, our largest concerns are with the renewal aspects of it, and part of that renewal is the substantial compliance. However, when we look at substantial compliance for the termination, that is something that we are continuing to work with the authors on. There is one thing I would like to mention about, there is a discussion about the auto dealers. That is a product franchise. We are talking about business format franchises. So that is an apples and oranges, and that's a lengthy discussion, and I can provide you some information on that.
Yeah, but what I'm getting at is that they're saying, look, for the ticky-tack fouls, I think you used, things that are just small violations, because, franchise agreements can be 40, 50, some of them may 100 pages long, right? There may be little provisions in there that you're technically in violation of, but, it's in terms of the basic terms of the deal, it's not a big breach. But are you saying that, are there certain things that in this bill could be read as qualifying as substantial compliance that you guys would be concerned, no, that's actually more of a material breach of the contract?
Obviously those 11 points are the ones that we would view as the major substantial breaches that would be.
But those are intact.
Those
right?
are intact.
So this bill doesn't change that.
They don't address those 11, sir.
Okay, so you don't have a problem with that from that side of things?
With substantial compliance, we have over 100 different business sectors, so we're continuing to look at this bill and working with the authors on that. I cannot speak for all 100 business sectors at this time. However, we do continue to work with the authors on the bill, and I'll have a better answer for you on that related to that substantial compliance with all those different sectors. It's just a little hard right now to say, how will this affect them?
Yeah. Could I just close a little comment,
Please.
Mr. Chairman?
Sure.
If you, I understand where you're going with this bill, and I think I agree with the intent here to protect small business owners who are all in a franchise agreement. But I really want to make sure that the rule of law, rule of contract, is protected as well. And I've advised clients, who are considering entering into franchise agreements, and I go through the agreement and I say, hey, there's a whole lot of things in here that you should consider before you sign this. But at the end of the day, if you sign your name to it, you agree to abide by the contract and everything that's in it. And if we aren't a society that, that allows for the freedom to contract and that makes those contracts binding, that's a problem, I think. I think that undermines the rule of law and undermines the rule of civil society. So I really want to make sure that we get this right. I'm not sure that I'm there right now, and I think that there's things that we need to continue to work on as this bill works through the process.
If I could.
All right.
Mr. Chair, if I...
So I just wanted to, I'll make a comment, and you can address that in your close, Mr. Holden, if you would. I think for me, and having seen this come through last time, there are certain functions, and we can argue about when government's effective, when it's not, but one of the most important roles that government provides is leveling playing fields. And I see this bill, as I did last year, as providing that leveling. The rule of law still is intact, and in fact we have, with the UCC and many other provisions, have stipulated what happens in contracts. This is one of those instances where where we're legislating how contracts are formed and kind of the framework around them, ensuring a level playing field when that bargain is struck. And that's why I think this is a very important bill, and that's why my recommendation. So other questions or comments from committee members? All right, Mr. Holden, you may close, and please feel free to address those concerns.
Thank you, Mr. Chair. I appreciate your comments. I also appreciate the line of questioning from Assemblymember Gallagher. And let me just say that that's why I led off by saying that we are continuing to work with the opposition. I think it is important to do that. This is not the only committee that this bill will be heard, and so we want to make it clear to this committee that we're not abandoning discussions because we think that they're healthy and can be fruitful. Having said that, the rule of law being what it is, we are also legislators. All of us are elected to be here to continue to represent the people, to continue to represent constituencies that have issues and concerns that may have not been properly addressed in existing law. And sometimes it's through evolution. Sometimes it's through execution. And then we see that there is a need to make adjustments. And then sometimes we see that the law is silent and we need to step in and fill a void. I think that what we're trying to address here today, as was pointed out by the chair and others, that there is an inequity. There is an out of balance in terms of the relationship between franchisors and franchisees. What we're trying to do is to put it more in alignment, because we are talking about small business owners who are doing, as we profess, is a major sacrifice, but yet a lot of courage to go out and be a small business owner. And to be able to do that and risk financial reward is the height of courage. And so we're trying to recognize in this particular relationship there exists some inequities that we think are important to fix. And I think that, as you've heard, there are still some areas that we'll be able to work on and tweak, but substantially we have covered a lot of ground from where this bill was last year. We could have let it die. Governor didn't sign it. We could have turned away and focused on other things. But it's that important in this particular instance that we stand up and stand firm for those small business owners who are saying continuously to us, don't let it die, bring it back. We tried to review the governor's veto message and address that. And so we hopefully this committee will review our efforts, appreciate those efforts, give us your approval today, and I ask for your aye vote.
Thank you. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner. No. Wagner, no. Alejo. Aye. Alejo, aye. Chow. Chow, aye. Chu. Aye. Chu, aye. Gallagher. Garcia. Garcia, aye. Holden.
Aye.
Holden, aye. Mainshine. O'Donnell. Aye. O'Donnell, aye.
Your bill is out. Thank you.
Thank you.
And that moves us to item 12, which is AB 1154. Mr. Gray. Good morning.
Good morning, Mr. Chair, members. Currently, you're being handed out some both mock-up amendments as well as a document from the Secretary of State's website regarding campaign finance disclosure. Document 1 are amendments. Under these amendments, only the individual house, building, apartment number, and street name would be prohibited from disclosure. In this bill, that means the city and zip code of applicants would still be available for public review. This also conforms these disclosures to the same level of detail we all are subject to under campaign finance regulation. These new amendments ensure a necessary level of transparency to scrutinize bad actors while protecting individual privacy. Members, there were some concerns raised about my bill in respect to the detail available and the compelling public interest of having detailed information available, and these amendments are intended or proposed to address those concerns. AB 1154 ensures that the residence and phone numbers of concealed carry permit applicants are not disclosed to the general public through a public records request. The bill does not restrict access to law enforcement or the courts. In order to own a firearm in California, individuals must register with the California Department of Justice. State law prohibits the DOJ from releasing registrants' information to anyone other than law enforcement and court officials. In contrast, concealed carry permits are administered by county sheriffs and police chiefs. Despite the requirement to comply with all firearm laws when applying for the permit, applicants' information is subject to Public Records Act requests unless they are a judge, peace officer, district attorney, public defender, or other protected public official. This discrepancy creates significant privacy concerns for law-abiding citizens who are put at risk of being targeted by criminals for home invasion and gun theft. While there may exist a compelling interest for the public to review and scrutinize the issuance of concealed carry permits, we must look for the most narrowly tailored policy to achieve that goal consistent in matters of personal privacy. AB 1154 brings the law into balance by allowing review of applicant information but prohibiting the distribution of individualized home addresses. Members, following Sandy Hook in 2012, a New York newspaper published the names and addresses of over 40,000 gun permit holders in the form of an interactive online map. These events caused such concern that the New York legislature passed a law similar to AB 1154 to protect the private information from being distributed to the public. AB 1154 is supported by the California Police Chiefs Association, the California Peace Officers Association, and Crime Victims United. With that, I would respectfully ask for your aye vote.
Thank you, Mr. Gray.
With
Your
me
witnesses in
today-
support.
Mr. Chairman, members of the committee, Ed Worley with the National Rifle Association. The legislature has already taken the action of shielding information. As someone Gray pointed out, currently government officials don't have this information exposed. But what we have is sort of a weird thing in California law. Government officials' privacy is protected, but civilian privacy is not protected currently in our law. What we are asking for is a very simple thing. If you're going to have a level of the playing field, you're going to have equity in information that's out there in the public, the civilians should be allowed to have the same privacy protections as government officials do. Government officials have the rule of law, they have the things, they have government agencies to protect them. Civilians like myself do not. It's a very simple thing that we're asking for is just very simply to protect the privacy of people who have gotten concealed carry permits. Across 43 states in the United States, this law is basically intact, that you have the right to privacy. As what's going on now in California law and other states, more and more people are getting concealed weapons permits. What's going to happen is you're going to have more and more people exposed to this. There have been problems out there with information just getting out onto the internet, as someone Gray talked about. And this is a very modest, very logical step in the process of giving citizens the same privacy rights as government officials now enjoy.
Thank you. Next witness, please.
Good morning, Mr. Chair and members of the committee. Tom Pedersen, representing California Rifle and Pistol Association. I first want to thank the author for bringing this important legislation forward. This is a common-sense bill that will protect the addresses and phone numbers of applicants and holders of licenses to carry a concealed handgun. Currently, law-abiding Californians are at risk of having their home addresses and phone numbers disclosed to anyone merely because they have such a license. As been mentioned, public defenders, prosecutors, and judges currently have that protection. This would only extend that to these other individuals so they can be treated the same. As the author mentioned, a similar law was passed in New York after a newspaper posted the addresses of persons licensed to own a handgun. The posting was on a website that displayed an interactive map, and it showed the actual locations of where these handgun owners lived. Criminals utilized the personal information to identify handgun owners, and several crimes were attributed to the release of the personal information, including burglaries. This is a balanced approach and maintains transparency of government while still protecting the rights and privacy of these license holders. There's no reason to wait until an incident occurs like the one that occurred in New York. The same thing can happen right here in California. It's important to pass this bill and protect Californians. I urge your aye vote on AB 1154. Thank you.
Next witness, please.
Mr. Chairman, Sam Perez is representing Gun Owners of California, and just to add one piece of reality to what my colleagues have testified in support of this bill, and we are in strong support of this bill. The situation in New York that the Assemblyman is talking about, very soon after the names were released, there was a very highly publicized case where an individual, a criminal, used that list to identify a gun owner. He then took a truck to the gun owner's home and found that doing his criminal intelligence, found that he kept his guns in a safe. He tied a chain to the safe, through a hole in the wall, jerked the safe out of the home, threw it in the back of a pickup truck, and stole the guns. And all of the information, it was well documented in New York by the media that this was done because he was able to find the fact that this person was an identified gun owner and was able to take those guns. This is a common sense protection for law-abiding citizens. And yes, criminals will take advantage of knowing where. It's a target list that they've been handed with the names and addresses. So we're in strong support of this bill. Thank you.
Thank you. Other witnesses in support? If you just give your name and association, please.
Mr. Chair, members, Aaron McGuire on behalf of the California State Sheriff's Association. Our formal position is support if amended, but we are in strong support of the underlying policy in protecting the disclosure of this information, and we urge your aye vote. Thank you.
Thank you. Any other witnesses in support? Seeing none, any witnesses in opposition?
Mr. Chair, members of the committee, Jim Ebert with the California Newspaper Publishers Association. We're in strong opposition to the bill. What's not being discussed here is, how this information is being used in the public's interest. Over the last several decades, and this information has been publicly available for decades without a single incident in California occurring. However, newspapers and the public have used this information to ferret out corruption and abuse of the decision-making process by those who are charged with the discretion to issue these permits, whether good cause is being used, whether someone is using their discretion as a means to further a political campaign, as was the case in Orange County. As is the case with accusations in Los Angeles County with Sheriff Baca. Without this tool, this very effective tool, the public will find it difficult, if not impossible, to prevent that corruption from occurring. As a practical matter, when this information is being sought, it is being sought through the California Public Records Act. In order to do that, someone has to submit a request to an agency for the information. That creates a record. And so if a criminal is going to use the Public Records Act to obtain this information, they're going to create a record of that request. And it just strains credulity, I think, to imagine that a criminal is going to do that and leave a trail, so to speak, in order to do that. You have a proven mechanism. And the interest that the sponsors are citing was the same interest that the Supreme Court considered when this was challenged in 1986 in the case of CBS versus Block. And the court dismissed the concerns that were raised as purely speculative. And for those reasons, you have a very effective tool for the public and the news media to use. And even with the amendments, it's not enough. The address information, again, is proven and it's effective. And when this legislature is balancing the interests involved here, which is your responsibility, the interests of the sponsors just aren't compelling enough to completely eradicate this very effective tool. And we strongly urge a no vote.
Thank you. Next witness in opposition, please.
Yes, my name is Mark Powers with the California Broadcasters Association. We share the newspaper publishers' concern that these permits are currently scarce, hard to get, and as such they have considerable value. Anytime government has control over a valuable resource, the public needs to have really absolute scrutiny over that, and so we would urge a no vote on this. Thanks.
Thank you. Any other witnesses in opposition? Seeing none, I'll bring it back to the committee. And Mr. Gray, I am not going to support your bill here today. And I think there's a lot of the testimony, especially the New York case, was about gun registrations, not specifically the CCW permits. And so we're not necessarily talking about the same thing here. And I think there's a public interest as well as that neighbors might want to know who on their block or who in their area has the right to carry a concealed weapon. So there's, I think, another public interest that's important there. And I'd also like to distinguish the statement of government officials, because, of course, to set the record straight, it's not all government officials. It is certain classes of government officials, police officers, judges, those who, it has been established, have a higher vulnerability to being targeted by folks who might carry guns. And I don't think other government officials, such as elected officials like ourselves or others, have the same standing as the police officers do, nor I think do the general public. So I'll just let you know I'm not going to be supporting your bill. Other comments, questions by committee members? Mr. Gallagher?
I had a question first on State Sheriff's Association had some concerns regarding that the reasons for denial of a CCW might be subject of a Public Records Act request, including convictions that might implicate the privacy rights of applicants. Has that been removed at this point? I didn't hear anything with regard to that issue.
That's not been addressed at this point. I'll let the state sheriff speak in more detail to the nature of their...
Okay. Are they here today? Or?
They were.
Well, if somebody does have the answer to that question. I think it's a slippery slope, though, to say that the public has a right to know who's exercising their Second Amendment rights. And I thought it was interesting that in the discussion from CBA, the permits are often not easy to acquire as they empower the holder with rights others do not have. Well, everyone has the right. Every law-abiding citizen has the right to exercise their Second Amendment right. And if we're saying that the public has the right to know who's exercising their fundamental rights, where do we draw that line? So does the public have the right to know where everybody on their block is going to church, exercising their First Amendment right? I think that this is a much-needed bill to protect the privacy interests of people who are just exercising their fundamental rights under the Constitution. So I'm going to support the bill today. I just wanted to see if there was any response to that issue with regard to what state sheriffs brought up.
Ms. Garcia?
And I don't know if it's an answer, but to piggyback and talk, I think it's crafting that balance between these different rights. And I think if we had a system that was the same for everybody and consistent, it'd be one thing. But we have a system where we don't have consistency. We have some officials, whether it's the sheriffs or other folks, who have discretion to give out these badges, and the bars are not set the same for maybe a regular individuals and have access to that sheriff to get out there and go through the process. And it might be a much higher bar than, say, I'm a friend of the sheriff. And we've had some cases that have been reported of those abuses and that abuse of the power, not just in this, but in general. So for myself, it's how do you balance that too, of the public records creates a sort of accountability, and if we're going to remove that, how are we replacing that accountability is what I would like to see. And that's my discomfort with this bill at this time. Not discounting what you're talking about, but I want to see that accountability then being replaced somehow. So do we just take away that discretion, or how else are we going to hold these individuals accountable? Because we don't have a system that's the same for everybody.